now. So go ahead, Lindsey.
Okay, excellent. Hi, everyone, and thank you for joining tonight. AsylumWorks, thanks for having me. I know that we have, we serve a similar community with very similar needs, and everyone is really quite impacted by long pending asylum cases. So tonight we're going to talk about these long pending asylum cases and how can you get those moving. For this conversation, we're going to focus on expedite requests as well as federal lawsuits. Commonly, we refer to this as mandamus. We're going to cover expedite requests briefly because in order to have a successful federal lawsuit or mandamus suit, then you have to show that you've tried to get your interview scheduled and you've done everything you can, but have been unable to get the asylum office to schedule your interview. So one of the steps to get an interview scheduled out of order is an expedite request. And we will talk about this a little more. So while there are no clear-cut rules that say you have to take these specific steps, there's no clear-cut rules that say you have to wait until this amount of time has passed to file a mandamus or a federal lawsuit. And each attorney you consult with may have slightly different advice or suggestions about what should be done or when to file. This information is based on my experience, is based on my advice, is based on what I believe helps you to set up a more successful lawsuit or set up the elements that will help you succeed and not just waste money or time and filing a federal lawsuit like this. So first, with the expedite request, anyone can file a request to expedite their case. You can file a request to expedite at any time. Whether your application has been pending for 6 weeks or 6 years, you can try to file a request to expedite. And the request to expedite goes to the asylum office, directly to the asylum office that has your case. And that is based on where you live. Your address determines which asylum office gets your case, and therefore that's who you send your request directly to. And we are going to talk in some detail. I'm going to give some advice about what what you should do with the request to expedite and how you prepare this. But first, I want to explain and put into context the very difficult situation that the asylum office is in. The Arlington Asylum Office, for example, has over 60,000 applications pending before them that do not have a decision. So if you can imagine one office dealing with 60,000 applications and then they receive hundreds a week or a month, this backlog just continues to grow and they simply do not have the capacity, the officers, the office space, the administrative staff to process this volume of cases. It is not an intentional act that they don't want to schedule your case, but it is certainly a matter of resources. However, this extreme lack of resources to process this giant caseload in front of them does have many detrimental and harmful impacts to those of you who have applications pending, and they are aware of that impact. They're not blind to that, but they are just so very limited in how many cases they can process and when. So when you file a request to expedite, it is incredibly important to take it as slowly and carefully as you can to really put together a strong package that explains why you, this individual, out of 60,000 other principal applicants, should have their interview scheduled out of order and why they should focus their resources on you. And that can be a pretty tall task because there are unfortunately a lot of people within the asylum system who have been separated from family for years, who have fled very tragic situations, who are dealing with complex trauma on a daily basis. And a lot of people are begging for their interview. So for your expedite request, there are some very important things to think about when you're preparing that. A couple of warnings, a couple of must-dos here. First of all, before you ask the asylum office to expedite your case for you, you absolutely must be ready to go. So what this means is that if you had your interview scheduled tomorrow, you could show up and you could be prepared to present your case and win your case. That's going to include making sure that your personal statement is finished. It's going to include making sure that you have all of the supporting evidence that you could possibly obtain to corroborate what you say has happened to you, to corroborate who you are, what you've done. The asylum office has to look at many variables. It's not just, does this person tell a story that is tragic and they deserve protection, but they also have to look, is this consistent? Does this make sense in the broader scheme of the country conditions of what's happened there over the last several years, of what's happening now? And is this person who they say they are? Do we have identification? Do we have relationship documents? Do we have things that just help us put this all together and show that this is really a case that is applicable under our asylum laws? So number one, make sure your case is ready to go. I think one of the biggest issues that I have for people who call me desperate to have their asylum interview scheduled is that once I start looking at the case, their personal statement isn't even complete, much less their supporting evidence. So at the most basic level, that has to be done before you try to take steps to expedite or before you file a mandamus in federal court. Also, another absolute must is that you must talk to your attorney if you are represented. Your attorney should be the one advising you on the request to expedite, on what to include, how to do this. They should be reviewing it. I also understand that there are a lot of attorneys who don't take the time or maybe who do not have the time to help with these. So that's why I'm going to go in a little more detail about how to help yourself, how to prepare these, what to think about. But before you move forward, before you file the request, if you are represented, please talk to your attorney. First, maybe they can help you. Second, just make sure they're okay with you expediting. If you have an attorney or if you're working within an organization who says, if you request to expedite and your interview is expedited, we cannot help you because we don't have the ability to represent you at an interview right now, then you need to decide, are you going to try to find another attorney or are you willing to go alone? So again, case has to be ready and your attorney has to be on board. All right. So increasing your chance of an approval on an expedite, because of course, an expedite request, if that's approved, is going to be a lot cheaper than you having to hire an attorney to represent you in federal court. So first, put all of your effort into this request to expedite, and that may give you the result that you need. You may not have to go on to this more extraordinary step of filing a lawsuit in federal court. With expedite request, you only want to focus on the need to expedite. The details of your case, what happened to you in the past, the strength of your case, who you were, the level of superiority that you had, none of those details matter. Only thing that matters, the only thing the asylum office can consider when they're reviewing requests to expedite is what is the urgent need to expedite. All of those other issues are completely irrelevant unless it's linked to your current hardship. So for example, I have clients who suffered extreme trauma in their home country, which has caused a very severe medical issue that has not been treated. And we need to work hard to get this case process so this person can get health insurance. Then that injury that happened then is important, but all of the details around it is not important. You don't need to spend your time explaining, I was arrested on this day and these things were said and this thing was done. Nope, this injury happened to me in my home country. I'm not getting treatment now and it's urgent that I do. So focus only on the need to expedite. Be very, very clear about the hardships that you're facing. You have to be clear and concise. The people who are reviewing requests to expedite have very little time. Remember, they have 60,000 cases pending. They have so many different tasks that everyone is responsible for. They receive hundreds of requests to expedite. They have to review these quickly and they have to decide within moments if this is extraordinary and if this warrants being plucked out from all those 60,000 people to give one of these very few and valuable interview slots to. So don't go on for pages and pages about not extremely relevant information. Okay, be very particular and very concise about what they need to know. The punchier it is, the more direct it is. No need to beat around the bush. Be very direct, be very concise, so that they can understand immediately the severity of the situation and exactly how they can help you get out of or fix this situation. So when focusing on the hardships, only focus on hardships to you as the applicant or to your immediate family members. Immediate family members for immigration purposes, especially within the asylum context, is your spouse and children. That is because they need to link your interview being scheduled and or your case moving along to the impact, the immediate result. The only immediate result to any family member with an asylum case can be to your spouse and children, because then you can start the process to sponsor them. If you've been separated from your parents for many years and you really want to be able to sponsor them and bring them to the United States, please don't put this in your expedite request, because the asylum office can't do anything about it. And when you're an asylee, you also can't petition for them. So that's not an immediate enough or a direct enough reason for them to expedite your case. So focus on you, focus on your spouse and your children, all who could benefit immediately if your asylum case was moved along. Let's see. So, of course, the meat of it, what can they consider? What will they approve based on? Keep in mind that separation from your family and mental health impacts are impacts and are hardships that almost every other applicant is facing. The unfortunate part of this system is that a lot of people are waiting for a very long time. A lot of people are suffering because of trauma they've experienced in the past. There are a lot of people with depression, a lot of people with PTSD, a lot of people with family living in dangerous situations. So if you put just a general letter in and say, I have PTSD and depression and my family is in a dangerous situation, it's almost guaranteed that the asylum office will respond to that and say, we are sorry, we've taken note of your situation, but we don't have the resources to schedule your interview. And the reason is because so many people are in a very similar situation and it's heartbreaking, and they just can't expedite everyone's case because they don't have the resources. However, those types of situations are things they can consider as long as you can explain and show that your situation or your family situation is really extreme. How is this not, I hate when I describe this and I say it's not a normal, results of depression, or it's not normal PTSD, or it's not a normal threats of insecurity, because all of these things are very important and all of these things are very harmful. But to separate yourself from the general experience or the general pool of people who also need the same benefit, you have to be as precise as you can be. One, in terms of safety, for your family, direct, immediate family members abroad, what are the direct or the immediate threats of harm? Have they been personally threatened? Have they had to move because the threats became so severe, for example? Typically just an unsafe environment is not enough. I will say that with the current situation, with a lot of Tigrayans being hunted down, the asylum office has been responsive to that, even if a Tigrayan hasn't specifically been detained yet. That one is more of a situation where the general harm towards this population of people, they've been more responsive to. But we have very many situations where someone's wife has been detained, or the cadres continue to threaten the spouse or the kids. Situations where there have been attacks on the home, frequent visits from the police. The more specific you can be about the danger that your family is facing and about how immediate that danger is, then the more helpful it is for the officer who's reviewing this request. Also, medical issues are very important. What are the medical issues? How does the lack of your status impact those medical issues? So, for example, if you don't have insurance because you don't have status, or you don't have the insurance you have isn't good enough because you don't have status, or you don't have the type of job that would come with a stronger type of insurance. Maybe you haven't received proper treatment. Maybe it's the medical condition is made worse by your distress, or by your depression, or by your anxiety. For example, I've had a client who suffered from rheumatoid arthritis, and this would flare up and she could not get it under control because of the level of her anxiety and depression. So we were able to get a doctor to provide a statement that said, one, my patient has this disease, but also we cannot get it under control because of the level of anxiety that she's experiencing. And we really need to be able to get this under control for her long-term health. Excuse me. Similar for family members abroad or here, if they have health issues and those health issues really need immediate treatment, then highlight for the officer, what is the medical need? How could that be addressed if they were here or if they had status, so they can understand the very immediate impact of moving this case along. Another area that's worth including, I don't think it's enough on its own usually to lead to an expedite request being granted, but my approach is to include all of the hardships, everything that has impacted you. I do it section by section, with the absolute worst one starting out in the beginning. But another type of hardship is hardships around stalled career paths or stalled education paths. And sometimes this has gone on for so long that it's impacted someone's mental health. So that part, you can discuss that, how that's impacted you. Also, how might the US benefit, or how might the local community benefit if you were able to continue in your career path because you were given status, or on your path to education that you wanted to complete medical school, for example. But with these areas that when we use these, we want to be very personal and very specific about it. One of my more recent expedite requests, the client was experiencing severe mental health impacts, suicidal ideation. She had even attempted suicide because of the level of depression she was experiencing. It was a very, very difficult case. but she also had very specific plans for her education. She wanted to be an engineer. She wanted to be able to work on clean water resources for disadvantaged communities across the world. So we included these things as, a part of her Expedite package. She's been waiting 6 years to be able to continue this education, and she hasn't been able to because of this process. So it's not that it's irrelevant, it is helpful. So you want to include all of the different issues, but with the intention of being precise as you can be and as clear for the asylum officer so they can know immediately, is this something I can approve or is it something that I can't? In terms of what to actually submit for the request to expedite, one, on a very administrative level, the Arlington Asylum Office has a one-page form that they want you to fill out and submit with your request. It's very basic biographical information: who's filing this, attorney or applicant, how do we contact you? Also include the personal statement, just including these details that I just explained. What are the hardships? How is this going to change for you if your interview is scheduled and if your case moves along? And then also supporting evidence. They're not usually going to approve a request to expedite if you don't have supporting evidence to help corroborate and show that what you're saying is true is actually happening. That does not necessarily mean that you have to have this very extensive psychological evaluation that talks about your depression and impacts from the case. However, sometimes this can be very helpful. So maybe it is one of your pieces of evidence. If you have family members abroad who are experiencing direct threats of harm and other issues, if you can get a statement from your spouse or from your kids or from their doctors or their schools, these are other types of evidence to think about and how you can support your request and prove that what you're saying is true. Now, when we think about this request to expedite and your supporting evidence before it is filed, please review, and review again. Everything that you submit, whether it's with your request to expedite or with your asylum application, will be considered by the asylum officer when determining if you warrant asylum or not. And if you've submitted something with your expedite request that is inconsistent with your story or inconsistent with something else that they have found, then this can impact your credibility and it can impact the decision on your case. So when you're putting these materials together, create a timeline on what date did what event happen. Have it all in chronological order so that then when you're reviewing your evidence, whether that's for your asylum case itself or for your expedite, make sure that everything is consistent and everything adds up and everything makes sense. Make sure to compare that to your personal statement. It's important that everything lines up, and I don't want you to rely on your attorney to be the one to catch mistakes. Your attorney should be reviewing everything before it's filed, but not all attorneys do, and no one's perfect and they may not catch your mistakes. So it's important for you to take ownership in this and make sure that you are doing your due diligence and everything that you can to make sure your case is whole, to make sure your case makes sense, to make sure your personal statement makes sense, the dates line up, the supporting evidence from friends and family, from the doctor. Everything needs to be consistent. And if there isn't something that is an error, if it's in an affidavit from a friend, for example, then just say, hey, friends, you said it was December, but it was November, so I think this was a typo. Let's correct it, please. I want to make sure this is correct. If it's a piece of evidence that is from an official source, but has an error in it, then you want to know before you submit it so that you're prepared to explain to the asylum officer. Or maybe it's something that's not even worth submitting to raise those questions. So review, make sure everything's consistent, and don't submit something without knowing that it's helpful for you instead of being potentially harmful or hurting your chance for an approval. So once you submit the request to expedite, the best way to do this is an email address. And Parisa, I will send you the form that has this information for you to share with everyone. There's an email address you can submit it to. If your request is more than 10 pages, then you should print it and also mail it to the asylum office. I prefer to email it. If it's over 10 pages, I say I'm also mailing you a copy, but that way they have it in multiple formats and hopefully someone will be reviewing it as soon as possible. They should respond within 30 days, but this varies significantly. I've had a response in as few as 3 or 4 hours with one expedite request I filed in the last 6 months, and then others take 6 weeks, 7 weeks. If more than 30 days pass, I will follow up. I'll say, hey, I want to make sure you receive this. We still need to expedite. Just a reminder, poke them again. Remember, they have a huge caseload. And so the more you follow up, don't be a nagging burden. Don't follow up every week, but after 30 days, it's appropriate to follow up. If they approve it,
right.
yeah.
I have one follow-up question about that.
Yeah.
And I think, so the standard form, do we request it from that email address that you're going to share later?
So I'll give you the standard form. And it's a good question, because since they've provided this standard form, that on the second page of it, they give you instructions of where to send it and what days you can walk in and file it in person if you wanted. Those details have changed. So, and they haven't provided like the latest updated form. So what I've done is on the old copy that I have, they'll still accept it. I've just typed over the incorrect information. So the form I'll send you, you can share with everyone. It has the correct email address. It has the right day that you can walk in person, which is on Thursdays. So I emailed them a few weeks ago in preparation for this to ask for the updated form so that I could share it with everyone, and they haven't responded with the updated. So I'll give you my updated version of that.
Great, thank you.
Yeah, and so if
we have the old form on file too, but if I think we also have the old standard form on file, but I'm sure it doesn't have the updated information.
Yeah, yeah, and I can send that so you can share that with everyone as they need. And so if the asylum office approves the request to expedite, then typically within 3 to 8 weeks, the date will be set. Again, it's totally dependent on resources. Normally it's going to be a minimum of 4. You can expect usually around 6, but they may even forget about it. And 60 days later, you may need to follow up and remind them that they approved your request to expedite and you would like for the date to be set as soon as possible. So now ask for you've asked the asylum office to expedite your case, explained your hardships that have been caused by this delay, and they deny it. So now what? Is that where things end, and will you be waiting forever? Not necessarily. So as long as you have filed this request to expedite, you've attempted to try to get your asylum case interviewed, then you can think about filing a lawsuit in federal court if your case has been pending long enough. And we use these lawsuits in federal court as a tool to move cases along when there has been an extreme delay. These lawsuits are filed pursuant to the Administrative Procedures Act, or the APA, and the Mandamus Act. We refer to these just generally as a mandamus complaint, a writ of mandamus, but there are 2 different acts that we use together in order to push these cases along. So the Administrative Procedures Act is a federal statute. This regulates federal agency action in a number of ways. And then we have the Mandamus Act, and in general, this can be used to compel or to force an administrative agency like like USCIS to act. Now, the court's authority The federal court's authority, even when you file one of these lawsuits, is limited to only telling or, demanding that the agency move on your case. The court cannot consider the merits of your case. Should it be approved? Should it be denied? Those things are irrelevant. It is really only about has the agency not met its mandated timeline for processing, or have they not taken a step that they're required to? So mandamus for short. I'll usually refer to that as we go through the next points and discuss these. So these actions are filed in federal district court. If in the United States, we have different levels of court. Some are state court, some are federal. Even within the federal system, we have different types of courts. So I'm not going to get into that because you would need to have an attorney to help you with this. Anyways, they can take care of the technical and legal aspects. Not all attorneys can file these cases though. So just because you're represented in your asylum case, it does not mean that your attorney who represents you for asylum can also file this lawsuit in federal court. You may have to hire a separate attorney to do that, or you may want to hire a separate attorney for that purpose. So just keep that in mind, that not all attorneys can be hired to file these. Now, to be entitled to relief under these acts for the APA and mandamus, the plaintiff, you as the person who has been wronged, has to show that the agency has unlawfully withheld action that it was required to take, such as when an agency fails to meet a congressionally set deadline. You also have to show that no other remedy is available. And so that's why you're coming to the court to ask for the federal court's help, because you can't force the agency to do something that they're supposed to do because you've already tried. In the asylum context, we file these lawsuits in a few different situations. First, in order to get an interview scheduled because one hasn't been scheduled for many years. Also, we use this when a decision has been pending for a very long time. So we've successfully done this with a few of our AsylumWorks clients. Decisions have been pending for more than a year. We've begged, we've pleaded, we've shown them what the hardship is that's coming from them taking so long on this decision. They say, I'm sorry, it's pending, we'll get to it. We can't wait anymore, so we file a lawsuit and they act. So both of those situations are common within the asylum context. Let's get an interview scheduled, or let's get a decision issued. So with the asylum cases, one of the reasons we can file them here when a decision hasn't been made or an interview hasn't been scheduled is because Congress has actually set out deadlines for processing these cases. In the US Code, it states that in the absence of exceptional circumstances, final administrative adjudication of asylum application shall be completed within 180 days after the application is filed. 180 days is quite laughable now. There was a time when applications were frequently processed in 180 days. And even now, there's a chance that that will happen, but it's very few and far between. So we can't file, I mean, you can file after 180 days, but it's very, very unlikely to be successful. I mean, any federal court is going to deny a petition if an asylum application has only been pending 181 days, for example. And I think what's important here for these actions is that in the absence of exceptional circumstances, so there actually are many exceptional circumstances that are impacting USCIS's ability to adjudicate asylum cases right now, and has been for years. So judges will be understanding of the different impacts that have led to this gigantic backlog and their inability to interview people in a year or 2 years, or even 3 years. Some attorneys are willing to file after 3 years. I think that's very premature. especially as we're coming out of the pandemic. When many officers, when they couldn't even go to the asylum office and they could schedule like 2 asylum interviews a day. So I think that exceptional circumstances would cover a lot right now. I do think that once an asylum case has been pending for 5 years or more, even though we're just coming out of the pandemic, it's a pretty safe time period to start thinking about filing a federal lawsuit, to file these mandamuses. So when we have, this other one, the delay itself has to be excessive. There has to have been hardships caused by the delay. And then you have to show that no other adequate remedy is available. This is where this expedite request, the denied expedite request, comes into play. Because you're actually going to say to the federal judge, I've tried what I can and it hasn't been scheduled. I like to include a list of any inquiries that have been made to get your case scheduled. Even if it's high, I would like for it to be scheduled. When can it be scheduled? They'll send this like very general response about how they don't have the resources to schedule. And also congressional liaison requests. A lot of people can ask their congressman or woman, whether it's your Senate representative or the House representative, they can reach out to the asylum office on your behalf. The asylum office is going to give them a very general response about why they can't schedule it. But all of those are very helpful pieces of evidence to show the federal court to say, see, I've tried everything and my case is stuck. One question that I get a lot is, well, will they retaliate because we sued them in federal court? No, your case is not going to be treated negatively because you decided you needed to take this very serious action and sue them in federal court. I know at the local level, at the Arlington Asylum Office, for example, leadership is very aware of the hardships that people are suffering because of these very extended delays. Normally for cases that have been pending for more than 5 years, it's pretty difficult to try to explain to a judge how a case that should have been processed in 180 days has now been more than 5 years. And the asylum office is not usually going to try to fight this in federal court. So what happens is we file the complaint in federal court. The asylum office is contacted by the attorneys who have to represent them in federal court. They say, hey, you've been sued in federal court. How are we going to defend this? And normally the asylum office will say, let's offer them an interview date and ask them to drop this lawsuit. So for those cases that have been pending for more than 5 years, this is the frequent trend that we see: file, negotiate, drop the lawsuit, and get the interview date. And then they're not holding that against you. They understand that you have very few ways to actually get an interview scheduled. And right now, actually, a lot of their interview slots are going to people who are filing these lawsuits because it's hard to defend a 5-year delay in court. And they just want to get this over with. So they're negotiating and scheduling these interviews. That is a general overview of the mandamus lawsuits. Again, like I said in the beginning, there's no exact checklist to go by, exactly what's the earliest time you can file a mandamus, or what exact steps do you have to have taken to show the federal court. In general, again, I feel like after 5 years is a pretty safe period. After trying to expedite your case, making an inquiry or two is a pretty safe way to show the judge you've tried to do what you can. And again, other attorneys may give you different advice. However, I don't want someone to have to waste their time and money, because this is an extraordinary action and can be very expensive. So making sure you have the pieces of your puzzle together that are most likely going to lead to the result you want is important. And that's where this information that I've given you today, this advice that I give to anyone who contacts me about this type of case, that's where this is coming from in terms of just trying to help increase a positive outcome for you. Parisa, please let me know if you have questions. This is a very big topic, so I may have gaps, and I'm happy to cover those.
No, you did excellent. Thank you so much for taking your time to do this presentation. Before I stop the session for the Q&A, I just wanted to ask one question that I think is a general one that a lot of people are probably curious about, but can you talk about maybe the costs, the court costs and fees associated with the mandamus action? Maybe it'll help people get a better understanding about if they want to pursue this, how much they should be looking to save, and et cetera. And then we'll stop the Q&A to do the Q&A session.
Yeah, absolutely. So just like with an asylum case, if you hire an asylum attorney, the fees can range dramatically. So you may have an asylum attorney who charges $3,000, or you may have an asylum attorney who charges $20,000 or more, or anywhere in between. Similar with a federal lawsuit. You hire an attorney, each attorney has different expenses, they have different fees. So the legal fees can really vary quite dramatically. I would say, especially in our area, the DC, Virginia area, if you're looking to file a federal lawsuit, like maybe 3,000 to 10,000 is going to be a pretty normal range you would come up with if you're shopping around. I think around 4,000-ish is where we've been able to do a lot of them, based on different facts of the case, based on different circumstances. We're always trying to be as fair as we can with fees, and if we can find ways to reduce those with the legal fees, the amount of time and work and effort that goes into this, then that's a possibility that as time goes, maybe we can get these down even more. There are fees that the attorney, that doesn't go to the attorney, but that instead goes to the court or to administrative processes. So for example, to file the federal lawsuit, you have to pay a filing fee of $402. So that's going to be on top of the legal fee. And also in a lot of cases, depending on the attorney handling it, a lot of times there's also what's called a service of process fee. I know for a lot of ours, we've got different attorneys that we work with also with these cases. So if we work with a team and we have to do the service of process through an administrative process, then that's going to be $398. If we don't have to use the service of process, then there may not be an additional fee for that, but depends on the circumstances, depends on where the person lives, depends on which court we're going to sue in, like file the complaint in, and that's based on where the person lives, how the trends have been going at that time. So sometimes we decide to file in the Northern District in Virginia, for example. Other times we may want to file in Maryland or DC. Different attorneys get these cases at the federal level, and depending on how they're responding to our lawsuits at any given time, it may decide our strategy of where to file, because maybe we don't want to deal with that attorney like pushing back at that time. So the fees can vary, strategy varies, but I would say normally, 3,000 to 6,000 is a pretty fair expectation. And also for AsylumWorks, we are looking at trying to do like group lawsuits. So it wouldn't be what's known as like a class action, but we are trying to sort of group people together who are super similar. For example, like their asylum application has been pending for a similar amount of time. They live in the same area, at least the same state. They've tried similar steps. So everything has to be quite similar to be able to file it together. And then you can share some of the cost. So it's not gonna like cut the cost in half, because a lot of work that goes into it is very personal. So we still have to go through each person's personal history, summarize their attempts to get their case scheduled, summarize the exact hardships to those people. But we can share the like the filing costs and things like that. So that's one way to possibly get it down. If there are people in really similar situations, and we're actually about to file our first group suit. It's not really a group, it's only 2 people, because of long pending I-730s. So the I-730 is the petition you file after you get asylum. We have 2 people who came to us, both from the same country, both have families living in refugees in a different country, both facing exceptional hardships, and they filed about a month apart. So we're going to try to file this together, try to reduce the fees for them, try to get a positive, movement, rather than having to do this completely separately. So as we sort of play around with this strategy, we may be able to get fees down even more for everyone.
Thank you. That was a very good, thorough explanation. And I should also, kind of add that for certain AsylumWorks clients, AsylumWorks can also help supplement some legal fees. But again, that depends on where you live, and where you're at in the process. And then we can determine, after doing like a brief little referral form, to see if you would qualify for that supplemental income towards that legal fee. But with that being said, we're going to go ahead and stop the recorded session so we can have everybody ask any kind